All rise. We will obey. The International Criminal Court is now in session. L'audience à la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Good morning. Could the court officer please call the case?
Thank you, Madam President. The situation in the Republic of Kenya in the case of the prosecutor against Uhuru Kenyatta, ICC 0109-0211. We are in open session.
Thank you very much. Yes, as usual, counsel, please introduce yourselves for the record, starting with prosecution.
Your Honours, my name is Ben Gumpert. With me today in court are Adeshola Adeboyejo, Sam Lowry, Shamiso Mbizvo, Pakiso Mochochoko, and Haido Duk. There's a constraint of space out of court, but still very much active on the team, Sylvie Wakchom, Katerina Kikalishvili, and Doug Grieve. Thank you.
Thank you. Defense team, please.
Thank you, Madam President. I'm Stephen Kay of Queen's Counsel. My co-counsel is Miss Gillian Higgins. I'm with Mr. Destereo Yatsi, who's my instructing solicitor. And then in court today, we have Mr. Ben Joyce, Mr. Keno Ghetto, Miss Kirsty O'Sutherland, Miss Katie Hovington, and Mr. Tom Obhoff, many of whom are making their first appearances at the International Criminal Court, but have been on the team for a long while.
Thank you very much, and welcome. Legal representative of victims.
Good morning, Madam President. To my right is Caroline Walter of the OPCV. Behind me is Anushka Semi, our case manager, and my name is Fergal Gaynor. Thank you.
Thank you. And representatives of the government of the Republic of Kenya.
May it please you, Madam President. My name is Gedhu Muigai. I'm Attorney General of the Republic of Kenya. I appear with Mr. Njia Muturi, who is Solicitor General of the Republic of Kenya. And we are assisted by Ms. Caroline Gishuri, who is working with us on this case.
Thank you very much. As usual, in order to assist translation and transcription, I would like to remind everyone to speak slowly and to pause for several seconds in between speakers. This status conference was ordered on 19th September this year, filing 954. The subject matter of the hearing is the status of the cooperation between the prosecution and the Kenyan government, which was ordered by this chamber in its decision of 31st March this year, filing 908. This is why representatives of the Kenyan government have again joined us today. And Mr. Attorney General, you and your team are most welcome. In terms of the schedule of this status conference, we will be sitting now until 12 o'clock sharp. The courtroom has also been reserved between 2 o'clock and 4 o'clock in case an afternoon session is required. I hope not. The chamber requests all counsel to please be concise and focus their responses directly towards the questions posed. At the outset, I wish to indicate that we do not intend to hear general submissions from anyone today, since we have already received detailed written submissions on the issue. The purpose of the hearing today is for the Chamber to receive further specific information on some very specific points in order to facilitate our decision making. We will be addressing direct questions to certain counsel and will not be opening the floor for everyone to comment on each matter. Additionally, you should not repeat submissions you have made previously, and you should also not make submissions on matters which have already been adjudicated by this chamber. You are also reminded to confine your submissions to the substance of the matters at hand, and to be professional and courteous towards each other at all times. For the smooth running of the proceedings, I would like to remind all counsel that if you wish to speak, you may indicate that by standing. However, please wait for me to give you the floor. Under no circumstances will interjections or interruption of other speakers be tolerated. As a final preliminary matter, in its order of in our order of 19 September 2014, the Kenyan government was directed to propose public redacted versions of filings 941 and 951 by 3rd October. This was not done, neither was the chamber seized of a request for extension of the deadline. It is recalled that the proposals need to be reviewed by the chamber, and that it is for this chamber to take a decision on reclassification. Therefore, the failure to provide the proposed reductions by the specified deadline means that it has not been possible to reclassify the filings ahead of this status conference. The chamber may refer in its questions today to certain information contained in those filings. Where we do so, we have determined that the matter may be referred to in this manner. However, you are reminded that we are in public session, and if at any stage you consider it necessary to go into private session in order to respond accurately or fully to a question, you may request that we go into private session. With this guidance in mind, we will now turn to the subject matter of this hearing. As you are aware, on 29 November 2013, the prosecution made an application for finding of non-compliance pursuant to Article 87.7 of the statute against the Kenyan government on the basis of a request for cooperation outstanding since April 2012. In our decision on 31st March this year, the chamber deferred the making of any formal finding of non-compliance until the expiration of a 6-month adjournment period granted in the main proceedings in this case. As that adjournment period has now come to an end, it is necessary for this chamber to re-evaluate the status of cooperation. During the course of the adjournment period, the chamber has received reports from the prosecution and the Kenyan government on the progress of cooperation, and most recently in filings 940 and 941 on 29th August. and the respective responses to those filings or observations thereto. First, prosecution and representative of Kenyan government. Can you please advise whether the status of cooperation remains as indicated in those most recent filings, or whether there have been further developments since that time? Have there been any further consultations, for example, or production of materials or information? And again, the Chamber reminds the participants to be concise and confine answers to the questions asked. Prosecution, please.
Madam President, the best guide to the current status of cooperation in my submission is to be found in the document to which Your Honour has recently referred, our filing of the 5th of September, namely observations on the Government of Kenya's update. And Your Honours will have found in that document a table which sets out, it's at paragraph 15, the 8 topics on which we have asked for the Government of Kenya's help and cooperation, and the current status of the cooperation provided. Your Honours have seen that. It's a public document, so anybody else who wishes to have seen it can also have had access to it, and I won't rehearse its content here unless Your Honour requires it of me. In short, there is a considerable body of material which the prosecution say should have been provided, could have been provided, and hasn't been provided. That's a matter which the Government of Kenya disputes. There is one update which I must make. Subsequent to that filing, the prosecution has received from the Government of Kenya, and is grateful for it, a letter from the Communications Authority of Kenya. And that is, of course, in reference to the 7th head, our request for telephone records. If Your Honour goes to the table I referred to, it's on the last page of the filing, telephone records request to identify numbers ascribed to, used by or associated with Mr. Kenyatta, and to provide call data records. And in this letter there is no substantive provision of any information. But if I may, I will just read from the first paragraph, because it crystallises in the prosecution's submission one of the problems which the court itself has identified in its recent decision, the July decision, resolving the disputes between the prosecution and the Government of Kenya.
Prosecution, can you just answer to the question posed? If there's you are saying that the only update is provision of this material.
It is, and I'm trying to briefly describe to Your Honours what the material is. If you only want me to...
Very briefly, please.
Well, I shall be very brief. The Communications Authority says that the release of the information required needs court orders compelling the licensees to do so, and that the authority is unable to compel the telephone licensees in the absence of such orders. And that absence of compulsion, the use of compulsion on the part of the Kenyan government, as opposed to the deployment of material which the accused has consented to providing, is one of the issues about which I need say no more, because the Chamber has already made observations about it.
Thank you very much. Mr. Attorney General.
Thank you, Madam President. First, I want to start with an apology to you and to the Chamber regarding our failure to file timeously the proposals for the redacted filing. My assistant was in contact with the registry as late as yesterday, and the impression we were given was that this would be cured by a formal application to you today for an extension of time ex post facto. We have it with us, our proposal for the redacted. It is signed and ready for filing, and we beg your indulgence that we should be able to file it this morning and apologize if it has caused any inconvenience. Secondly, Madam President, it is true, as my learned colleague has pointed out, that post the filings that are currently before court, there has been no further development except the letter that I directed to him, which came to me from the Communications Authority of Kenya, and that is dated the 1st of September 2014. My colleague has mentioned, Madam President, that this letter is evidence of how this process is not yielding the outcome that he would wish for. And maybe with your permission, I can comment on that, because what he has said is actually far from the truth. The Communication Authority of Kenya.
Mr. Attorney General, prosecution just explained what was written in this communication from Communication Authority. Do you disagree with what prosecution said?
Absolutely.
I mean, the factual description
What he
of
has
this
failed
letter.
to tell you, Madam President, is that the communication from the Communication Authority of Kenya must be read hand in hand with the communication from the two service providers, which was provided to him earlier. That was Safaricom and Airtel. And they explained what I had explained here before, that prior to 2009,
Mr. Attorney General, I think the chamber already knows about all those details.
That's
about
right.
the communication from Safaricom and other.
and Airtel.
Yeah.
Very good. Then
So if just you can confirm that the only development since your most recent filing, this provision of this communication from
the Communication Authority of Kenya.
That's fine.
That is
Yeah,
correct.
Thank you. Now we will turn to the specific matters which the chamber would like addressed further. Prosecution. We note that in your letter to Kenyan government dated 20th August this year, you gave notice requiring either provision of the outstanding materials or entering into good faith consultation by the Kenyan government, failing which you'd seize the chamber of the matter. Do you consider the terms of that letter to have been met? And I recognize that you have already answered partially to this question, but you have the floor, prosecution.
I'm grateful for that, and I have the letter in front of me, the letter of the 20th of August addressed to the Attorney General. Could Your Honours just direct me to the passage which is concerning Your Honours? Have I made myself plain? It may be that I've not spoken very clearly. When Your Honour began speaking, I didn't have the letter open in front of me.
Okay. But you now
I do now, and I wondered if the court could help me by drawing my attention to the passage in the letter which is concerning Your Honours. I note that it's in the first paragraph that
I think this is the public Annex D to your filing 940.
Yes, I have the letter.
And, yeah, and you said in this letter, so, last.
I think it.
It is the first paragraph.
Yes.
That you said that the purpose of this letter is to give notice that unless government of Kenya provides.
Yes, I did, or the Office of the Prosecutor wrote in those terms. Your Honours will recall that at this time, the prosecution contends that there had been a 2-month gap since anything at all had been received from the Kenyan government, despite, we contend, our writing regularly to them, asking for the promised help. The purpose of this letter was to say, well, to put it bluntly, if you've cut off communications with us altogether, which is what we fear from your recent silence, we're giving you notice that the OTP considers the consultations to have been exhausted because you're not responding anymore. This letter was followed within 2 days by a quantity of material which is outlined in the table to which I have drawn Your Honour's attention. So this letter does not represent the last word, and there has been further partial cooperation subsequent to this. The position is that certainly there has not been, we say, complete compliance, and therefore the deadline which we set has passed without there being complete cooperation in accordance with the Chamber's order. I think that is the best answer I can give.
Thank you very much. Does that mean that you intend to continue consultations with the government indefinitely until the cooperation request is fully executed? Or do you consider there is or will be a stage at which they are exhausted?
That's a hard question. When one party to cooperation proceedings is simply silent, does not respond to the other party, then after a reasonable period of time, the party to whom no response is being made is entitled, I submit, to say, right, well, this process is exhausted. It would be wrong to say that there has been no provision of information, and wrong to say that we have no expectations or hopes of any further material at all. What we have concluded is that the position of the Kenyan government, despite this Chamber's ruling, is such that the information which we truly require, let me give 2 examples, the best 2 examples perhaps, the full 3 years' worth of bank statements and the tax returns. I'm speaking in very precise terms here, exactly those things, the tax returns. I can actually show Your Honours such a document in blank, if it would help. They have not been provided. There is no sign of them being provided, and the lengthy explanation given by the Government of Kenya in its observations, which Your Honours have referred to on the 15th of September, say nothing about these documents being provided. I think it would be reasonable for us to conclude, and effectively we have so concluded, that the Kenyan government does not intend to provide us with either of those 2 sets of documents. And if that conclusion is correct, then at least in that respect, cooperation has been exhausted. There may be further such letters as the one I referred Your Honours to today, but in terms of really moving forward this process, it would appear that we are at a deadlock.
Prosecution, when you say we are at a deadlock, do you think, yes?
By that, I mean that the Kenyan government is not going to give us what we are asking for and what the Chamber has approved are asking for.
Do you mean that in prosecution's view, that the consultation be exhausted and you will go back to your original application under Article 87.7?
We do, yes. Our position is that if the definition of the term is exhausted, is to be understood to be effectively at an end, that's where we stand. And the logical conclusion to be drawn from that, indeed, I would say the only conclusion to be drawn from that, is that we revert to the position we first occupied, namely that if the court is satisfied that our arguments are right, it should make a finding of non-compliance on the part of the government of Kenya.
Thank you very much. Related question, prosecution. During the status conference on 5th February this year, you indicated that the possibility of obtaining sufficient evidence for trial as a result of a recall request is highly speculative. Has your assessment changed through the consultation with the Kenyan government during the 6-month adjournment period? For example, are you more sure that if you can have tax returns and full 3-year bank records, your possibility of obtaining sufficient evidence be less speculative?
It's difficult to measure degrees of speculation. We say, frankly, that we don't know what is contained within these records. There is a body of evidence, some 9 separate witnesses, who would be prepared to come forward and say that they were told by people who approached them to organize violence that the person who was financing or ultimately coordinating that violence was Mr. Kenyatta, and that they would be paid for their work and that they would be protected from the consequences of what they did. It is on the basis of that evidence that the prosecution has made the inquiries which are designed to reveal communications in terms of the telephone evidence we've asked for, and transfers of money or land or other benefits, which we hope will be revealed by the other requests that we have made. As to what the records will actually show, we still remain in a position of speculation. It is fair to say, and I say it openly, that nothing in the 75 pages of material which we have received from the Kenyan government makes the case against Mr. Kenyatta any stronger. On the other hand, we have not received material which might be regarded as the truly critical material. I don't want to rehearse submissions I've made before about the likelihood of somebody who is involved in offences wanting to cover their tracks. But the requests we have made are those which we could best design to uncover Mr. Kenyatta's involvement if there are records which would reveal it. We haven't seen the large majority of those records, and therefore we can still only speculate what they say.
Thank you very much. Now I would like to turn to Mr. Attorney General. From the exchange of correspondence, which the Chamber has carefully reviewed, there appears to be a period of over a month this summer, following the status conference on 9th July, during which the prosecution sent 3 letters relating to the revised request without receiving any response. Can you please comment on the reasons for that period of non-communication from the side of Kenyan government?
I'd be very happy to do so. First, Madam President, this chamber will appreciate that a government, even that of a small country like Kenya, is a fairly huge bureaucracy. The filings we have made demonstrate that when I received a letter on the 31st of July 2014 proposing that the prosecution and I should get together to push forward the matters raised in your decision of 29th January 2014, I immediately commenced consultations within government. And it is on record, for example, that on the 6th of August, which is not a month after your ruling, on the 6th of August, I sent off communication to the Registrar of Companies. I sent out communication to the Communication Authority of Kenya, to Airtel, to Safaricom, to the Central Bank of Kenya, to the Kenya Revenue Authority, to the Ministry of Lands, to the National Intelligence Service, to the National Transport and Safety Authority. If we desired to delay or obstruct, there would have been no reason for me to commence these consultations. And these consultations were not commenced under any compulsion. It is because whatever our views were as to what the court meant in its order of 29th, we wanted to be able, in good faith, to demonstrate that we were doing something about it. There has been a misconception that by some bureaucratic fiat, it is possible for the Attorney General sitting in his office.
Mr. Attorney General, please be more focused on my question.
Yes.
So the reason of this non-communication being that you took time to communicate with other internal organizations of Kenya?
Absolutely.
Is that what you
and
said?
not only that,
saying?
Madam Chair, very soon thereafter, in the very same month, 2 weeks after I communicated with other agencies of government, the information started flowing back. And as soon as the information came back, I sent it directly to the prosecutor. And one of the difficulties I think we have here is I have personal charge of the response of the Kenya government to this matter. The prosecutor who files documents in this court does not appear to have day-to-day charge. So I'm talking of things that I have done. The prosecutor has filed documents about things she was told by her staff who were told by her other staff. So the choice really must be yours, who you are to believe. But if you look at the record, Madam President, it speaks for itself. On the 25th of August, the Minister for Lands wrote back to me with an extensive report about whether or not she was in a position to assist the court.
Mr. Attorney General, the chamber has already examined all those materials which you
But allow me to say
submitted.
this, Madam President. It is not for one lawyer to determine whether there has been cooperation. It is for the court. In the manner that the prosecution addresses this matter, the prosecutor is saying, until I am personally satisfied.
Mr.
There has been
Attorney
no-
General,
Yeah.
I'm sorry to interrupt,
Yes.
but I think you have already answered our question.
Yes, but I need to, may I also finalize by saying that you will notice that by the end of August, all the responses had been made. They were not made because we were being prompted by the prosecutor. They were made because it was our obligation to the court, which we had undertaken, to come back with these responses. And therefore, Madam President, you must allow me to answer the same question you have asked the prosecutor. Has the cooperation process ended?
No, Mr. Attorney General, as I said at the outset, we are not opening the floor for every counsel on every point. This is this status conference, but the purpose of this status conference is for the chamber to ask very specific question to very specific counsel.
Well, would it not then, Madam President, be very unfair for us that he should be able to say whether in his view the cooperation has ended, but we have no right to state, in our view, what is the status of that cooperation?
Mr. Attorney General, this is status conference
Yeah.
in order for us to gather information, and that's it. Another question, Mr. Attorney General. We note that in the joint submission of the prosecution and the Kenyan government, which was filed on 8th July, it has indicated that there has been an agreement in principle for the provision of supplementary information and for meetings to be facilitated by certain deadlines. Those deadlines expired during the period of non-communication just mentioned without any explanation having been provided. And the Kenyan government stressed in its most recent submission that it was an agreement in principle, but without again mentioning any explanation what exceptional circumstances had prevented it from executing this agreement. Can you please explain why that occurred?
The reason no meeting was held is explained in both my filing and the prosecutor's filing. And it is clear from the prosecutor's filing and my own filing that we were completely at cross purposes. And again, this is where, if I may say this again, I spoke to one of the prosecutor's assistants, Mr. Muchachoko, who is in court, on the telephone. We mooted the idea that he would be in Nairobi. He was in Arusha. I mooted the idea of hosting him in my office. We discussed it at some length. He came back to me and said the period of layover, because it was a Friday to Monday, was too long to be justified, and he was unable to come in. That's part of my record. My assistant, sorry, madam.
So your submission is that actually you suggested certain timing for this meeting and the prosecution was not able to come on the suggested date?
It is in the filing. And we then wrote an email. There was an email from my assistant again saying, when will the prosecutor be available for a discussion about these outstanding matters? That email was not responded to.
Thank you very much, Mr. Attorney General. But my understanding is that in prosecution's submission is that this meeting has nothing to do with this case. Am I correct? Prosecution.
Your Honor is correct.
That is the heart of the problem. The person claiming that the meeting we were to have was about something else is the person with whom I didn't have that conversation as to what we were meeting. I am here to speak for myself, that I called a certain person who I have named by name, who I then told, let us meet and advance the discussion. That person is not saying that that conversation didn't happen. Some other third party is saying that that conversation didn't take place. I wrote an email, my assistant wrote an email asking for a meeting to discuss this matter. That email was not responded to, and I don't hear it being said now that the email was never written. Be that as it may, what then followed was a process through which we were communicating in writing, almost on a daily basis, or every 2 days. And I was saying, now find here enclosed what I have received from the National Security Service, etc., etc. I consider that to be a continuing consultation.
Thank you very much. Another question, Mr. Attorney General, about the current status of the cooperation and the way forward. In your most recent filing, Mr. Attorney General, that is the observation you provided on the prosecution's update, you indicated that the reason why some of the material sought in the revised cooperation request remains outstanding is because the prosecution has not provided certain information. Is it your position, Mr. Attorney General, that you have taken all steps available to you and that you cannot progress the cooperation any further unless the prosecution provides this further information?
That is our case, Madam President. It is not a new case. It is the case we informed the court the first day we came here. It was the case we informed the court the second day we came here. It is the case we are informing the court again today. We have now documented it at great length. Allow me, Madam President, very briefly to talk about the land records. We have set out, we have given my learned colleague all the laws of Kenya relating to land and all the forms that anybody, including the Kenya government, must fill in order to get a report relating to titles. We have begged this court before, and we do so again. I think
the chamber has all information
but
about those
may I make this
conditions.
point, please, madam, because I need to answer you. It is true. Unless the prosecution is able to tell us, we are interested in land reference number 100, please get us a search on that title. And I have promised you, if that happens, we will bring the search within 72 hours. We have also said, if you know of a motor vehicle by its registration, and you give me the number, I will bring the logbook that tells us who owes that number, and I will do it in 72 hours. If you have a telephone number, we will be able, post 2009, to ask the providers to give us the name and the logs of the telephone. If you want to know who owns which trust, you have to give us the name of the trust. And within 72 hours, we will bring you all the particulars. Unless the prosecution, Madam President, takes itself more seriously on this matter, we are we are put in a most embarrassing and difficult and impossible situation. Because we are being asked, use the entire machinery of state to find out something that the law has created a procedure for.
Mr. Attorney General, but as you said, for example, that you say in order to provide the prosecution with necessary information about telephone communication, your government needs, for example, a personal identification number issued by the Kenyan Revenue Authority. Do you really consider that to be a reasonable position?
Absolutely.
For the government to take, that the prosecution must provide a PIN issued by your own domestic revenue authority?
Because, Madam President, this is the requirement of the law to be able to conduct a land registry search or a company registry search. You must have the name of the company, the name of
Mr. Attorney General, my example is personal identification number issued by Kenyan Revenue Authority.
It is not the personal identification number that facilitates the entire search. The personal identification number is a number that you provide the registrar with alongside other documentation, including the names of the directors, the shareholders, the name of the companies, the name of the company secretary, etc., etc., etc. So that I have no way of knowing the personal identification number of Mr. Uhuru Kenyatta. This is something to be supplied to me to supply to the registrar. Unless an argument is being made that the government has a surveillance system where every person's personal identification number, the equivalent of a social security number, is available willy-nilly. It is not. This is information, and I want, Madam President, that you should allow me to make this point one more time.
I don't think you need to repeat.
Request.
Mr. Attorney
request
General.
is not for me to
Mr. Attorney General.
Madam President.
I think I don't want you to repeat anything. And just my apology, I get confused. This PIN is something you
It's like a social security
for the,
number.
yes.
Yes.
Something for land records rather than telephone records.
No, no, no. It is a number. May I explain that, please?
No, I don't think you need to explain.
Very
I now
well.
fully understood.
Very well.
Prosecution. I would now like to return to you on this point. Could you please comment on the Kenyan government submission about this further information, the necessity of further information from you in order to execute the cooperation request?
I can, and I think I can best do it by giving an example. And the example is the telephone request. In the course of gathering information, 2 prosecution witnesses and a number of other people to whom the prosecution has spoken or from whom we have been provided with statements have suggested that at relevant times, Mr. Kenyatta had a particular telephone number, which ended in the numbers 891. In cooperation with the defence, we have caused inquiries to be made into the records relating to that number, and we have received some. Sadly, those records are very partial. Relating to the relevant period, we only have records of telephone calls which were made to that number, not records of telephone calls which were made by that number. So we've got incoming, not outgoing. Furthermore, over the period of December 2007 and January 2008, that telephone number, if it was Mr. Kenyatta's, as we are informed it was only in contact with 5 other numbers. Thus, we confidently assume that the records we have do not represent the entirety of Mr. Kenyatta's telephone contacts at that time. We don't have access to any other number which is said to have been Mr. Kenyatta's at the time. And therefore, we are not in a position to give the Attorney General what he says he wants, because we don't have that information. It is indeed the information which we are seeking from the Kenyan government. We suggest that the idea that the Kenyan government doesn't have records of telephones being used by cabinet ministers, as Mr. Kenyatta was at the relevant time, is an unrealistic one, and that if they were to do a diligent and proper search in their own records, they would come up with the numbers which were being used. And if they did that diligent and proper search, they would then be able to provide those numbers to us and to the telephone service providers, and there would be at least the hope that we would receive the same kind of records as those which we have received in respect of the 891 number to which I have referred. But it is simply a circular argument for the Attorney General to say, I can only give you the records if you give me the telephone numbers, because it's the telephone numbers which we are asking for. He knows that that is material which we say the Kenyan government must have, and which we're asking them to provide to us as a springboard for other material. That is an answer in respect of just one of the 8 heads of inquiries that we have made. But I hope that it illuminates all 8.
Madam President,
Thank
may
you
I
very
have
much.
your
Mr.
permission-
Attorney General.
May I have your permission very briefly to respond to that, because this is in fact the heart of the problem before this court. We have an investigation that has taken place for 5 years. We have an investigation team and a prosecutor who has come to you repeatedly and said, we are ready to proceed with the case because we have evidence. What Kenya is supposed to do is to cooperate to facilitate in confirmation of the availability of material. What the prosecutor has just admitted to is that they have never known, have never had access to what they said in their speech here before you. In his speech before you, he said, we have critical information. Critical information. He now says they've never had it, and they would like the Kenya government to help them to find it, because the Kenya government must be assumed to keep a register of phones used by cabinet ministers. There is no offer of evidence that Mr. Kenyatta's phone was a phone assigned to him as a cabinet minister. This is the sort of circumlocucious argumentation that we have heard, that we are saying to you is not useful. And I want to repeat this, Madam President. The only reason the prosecutor admitted to the court that he knew of telephone numbers belonging to Mr. Kenyatta is because we raised it. We came and told you, Madam President, that Mr. K, as a defense lawyer, and the prosecutor, behind our back, and they were not supposed to tell us, had gone to court.
Mr. Attorney General, I'm sorry to say that you are against that.
Okay,
repeating.
sorry. Let me wind up then by saying our position remains the same. All these witnesses that are referred to by the prosecutor, to whom phone calls were made, surely must have received phone calls from specific numbers. Give me those specific numbers, give me 72 hours, and I'll bring you the phone logs.
Thank you. Prosecution. In your correspondence with Kenyan government, certain explanations have been provided as to why the request for company records and land transfer records cannot, as a practical or administrative matter, be executed directly. And the chamber understands that two records are quite important for the prosecution. Leaving aside for the moment the possibility of obtaining the information through alternative means, such as tax returns, are you satisfied with the explanations that have been provided about the practical and administrative difficulties? That is, do you consider that it is in fact necessary to resort to alternative means for obtaining that material?
Madam President, the prosecution isn't really in a position to judge. The Kenyan government has the advantage that it speaks directly to the people who are responsible for the organization of the company records and the land registry. They have indeed provided quite lengthy explanations as to why it is quite impossible to do what I myself would have thought would be a primary purpose of keeping these records in the first place. That is to say, to be able to consult them to establish what land holdings or what interests in companies a particular individual has. It certainly doesn't lie in my mouth to call the keepers of those records untruthful in the letters that they have written. I am in the position that I have effectively to accept what they say because I have no means of challenging it. If indeed it is the position that the Kenyan records of its company, the Kenyan Register of Limited Companies and the Kenyan
That the Kenyan government may be best placed to advise on alternative possibilities under the Kenyan domestic framework for obtaining requested material. And I understand from your submission so far that the Kenyan government did not advise any alternative measures for obtaining any of the information sought.
No, we have advised the prosecutor and have advised the court on the legal and administrative methods that are available in Kenya for obtaining the information he requests. We have
no alternative measures to overcome those difficulties.
We have no extra legal or extrajudicial measures. Except the legal measures we have given, we are unable to use extra legal, extrajudicial measures.
Judge Freeman.
Mr. Attorney General, maybe I will have two questions concerning the last issue. Does it mean, or is it my understanding that in case in Kenya you have a accused who is prosecuted for serious crime and there is a need to investigate his assets, like in this case? And does it mean that the only chance to get the details necessary for making further investigation on his cars, on his on land owned by him, is to ask him for further details?
Judge, I want to confirm that the request we have received from this court and from by the prosecutor is not any different from a request we receive daily for mutual legal assistance. And a request for mutual legal assistance requires the requesting state to provide the information, the basis upon which evidence can be assembled in the receiving state. The difficulty we have in what is proposed before this court is that we are required to assume responsibility for identifying the evidence itself. I have explained before, Judge, the difficulty we have with that. A, because the Republic of Kenya is not a party.
Thank you, it's clear to me, but take a case of your domestic investigation.
Yes.
So it's just your responsibility probably to be initiative. So in such a case, again, you just have to rely on consent, and I can even imagine that such accused could be even missing. But you know, you have a need to investigate, he's missing, so in such a case you have in fact no practical chance to make any further investigation on his cars, on his lands and so on.
If in a Kenyan court, a prosecutor or an investigator was to acquire evidence illegally obtained evidence, it is inadmissible in court. And even if it were admitted, it would be of no probative value. It is not a method we have used before. I would hope that I'm not being invited by the prosecutor to consider extra legal.
No, it's clear. And the last question, excuse me, Mr. Prosecutor, Mr. State Attorney, from my part, we also discussed this possibility of asking for approval from the accused. Have you also considered this possibility? Because hypothetically, you could also ask Mr. Kenyatta whether he is willing to cooperate with you. Because, okay, I fully respect there is a right not to self-incriminate himself. If he would say, okay, I don't want, it's clear. But I also can imagine possibility that he would say, okay, I want to prove that I'm innocent and I will provide you with those details. Have you considered this possibility?
Not only have I considered that, but in some respect, we already acted on the bank statements on that principle. And if I remember correctly, the prosecutor made heavy weather of it when we were last here. If you recall, Judge, the prosecutor was very, very unhappy. He said that the Kenya government was only willing to bring information which the accused had consented to. And the argument we were making at the time was, it is much easier, and Mr. K, I think, will speak to this. When Mr. K and the prosecution wanted telephone records, both of them got together. They went to Safaricom, they went to Airtel, they got the records. They both have them. I don't. When we wanted to have the bank records, and we were confronted with the difficulties with central bank, with the individual banks, Mr. K himself, having had the discussion we had here, wrote to me a letter saying, and I think copied to the prosecutor, we have no objection to bank records being obtained. That is how we obtained the bank records. I hope I make myself clear, Judge.
Okay, perfectly clear. And as to the other details, because it's nice, but also there is some request for further details concerning cars and land. Is it not possible to go this way as well?
Yes, but that would not be a duty of cooperation on the state on the whole. It would be a duty of disclosure. And the record of this trial that is public shows that when in 2012 the prosecutor said they were ready to proceed, the prosecutor was reprimanded on 4 different occasions for failure to disclose. These are the disclosures. What is now being prosecuted through the back door as an application for cooperation is a breakdown in the ability of the prosecution to conduct A, proper investigations, B, to disclose mutually to the defense. We are being made sacrificial lambs about a matter that has nothing to do with the Republic and has something to do with the professional conduct of the case.
Thank you very much, Mr. Attorney General.
Now turning to another record, which is tax returns. Mr. Attorney General, the prosecution has been requesting the provision of Mr. Kenyatta's tax returns during the relevant time period. While the Kenyan government has provided certain tax-related materials, it has not provided these requested tax returns, nor provided an explanation for not doing so, like legal or administrative difficulties. Can you please comment specifically on why those tax returns have not been provided?
Give me a moment now. These are not foreign exchange transactions.
Tax returns.
Yes, on the 26th of August, Madam President, I received a letter which I have appended from the Kenya Revenue Authority in response to my letter of 6th August, which I mentioned earlier. And I think that the supplement, Madam President, I don't know whether you've seen it, the letter of 26th August 2014.
Is it annexed to your submission?
Yes, it is.
Can you...
Can I read it for you? It's very short.
No, if you can just tell me annex number, that will be okay.
It's annexed to our submissions of 29th August.
Yes, and which annex?
Annex 47? No, not that one, sorry. Yeah, we've got the letter. Yeah. Annex 5.
Annex 5 to your submission dated 12 September. Is that the one you are referring to?
Is it dated 26th August 2014?
No, it's dated 19 July.
Kenya OTP 01400073. It's 13, I believe, 15. 30, I believe. Sorry for that, Madam President. I think we got it, it's 30.
Okay. Annex 30.
(31) 30 and 31, there are two joint letters.
Yes, 31 is the letter from Kenya Revenue Authority.
Correct, Madam President. That is the letter. Availed to me, which I availed to the prosecutor, were hard and soft copy of the income tax declaration form for 2009-2010, and the confirmation that the person in question was not registered for VAT. There is, sorry, madam.
Yes, but the what prosecution is asking for is tax return for of the accused, not only the information about VAT.
That's exactly what I have given, madam. May I read that for you, please? The writer says, we have touched both in hard and soft copies the income tax declaration information for 2009-2010. He explains there earlier, the information we have provided represents what our records contained based on returns submitted by the taxpayer. For the 2 years in question, the taxpayer filed income tax returns and paid the self-declared taxes. So that has been provided.
Yes, but the letter also mentions the taxpayer filed income tax returns, and I think that's exactly the material prosecution is seeking. Am I right, prosecution?
I think there is a slight, okay, let me be my colleague.
I have in my hand a blank Kenya Revenue Authority tax return. It is, unfortunately, familiar to many of us probably in its general form, full of boxes which have to be filled in, including, for example, space for details of directorships held by the person making the return. It's the kind of information which has to be included in all these boxes which we're interested in. We don't want to know how much tax Mr. Kenyatta has paid or how that's been calculated, which is the essence of the document we've been given. We want to know what he says about things like his directorships of companies and other financial details which this form will require him to provide. With the greatest respect to my learned friend, we couldn't possibly have been clearer that it is the completed versions of this document that we want, and we haven't got it.
Thank you, prosecution. Mr. Attorney General.
My understanding of how this authority works, Madam President, they have explained in that letter. One, they say we operate a self-assessment tax regime where taxpayers make own declarations which we may interrogate based on risk profile. What I understand that they do, Madam President, is that a tax form return is filled, they extract information that they consider to be relevant. They retain that information which they have extracted in a format that they use for their other purposes, but they do not retain the forms. That is my understanding. So that what we have been given in hard and soft copy is the income tax declaration information that is retained routinely by the authority.
So, Mr. Attorney General, what you are saying is that the Mr. Kenyatta filed income tax return,
yes,
that kind of format which prosecution showed, but the revenue authority does not retain those.
It doesn't retain the form. It extracts from the form. The letter is self-explanatory. The information we have provided represents what our records contain based on returns submitted by the taxpayer. For the 2 years in question, the taxpayer filed income tax return and paid self-declared taxes. That is how they work. It may not be the most efficient system in the world, but that is the system that we have.
Thank you very much. Now I would like to...
I'm very sorry to interrupt, Honor, but
Yes,
that's a
proceed.
piece of information which I don't believe we've had before.
Sorry, could you repeat? I didn't
Yes,
catch.
I'm sorry, I interrupted, my fault. But this is a piece of information which I believe is new. It is, in fact, further purported cooperation, but I just want to be clear. The position of the Kenyan government is that Mr. Kenyatta filed tax returns, like this one, but they have subsequently been destroyed, so they are not available to be given to us. Have I understood correctly?
I don't know whether my learned colleague wishes the court to believe that he never received the letter that I communicated to him, 26th August, and that he's seen it for the first time this morning, or having received it, that he didn't read it, or having read it, he didn't understand it. Because it says exactly what I am saying. It says we have extracted...
Mr. Attorney General, I have to confess that this letter is not so clear about the whether the Revenue Authority retains all those documents or not. I think that's why the prosecution is saying
We'll
that.
take your assurance, madam.
I don't think prosecution is saying that he hasn't read.
Okay, very
the
well.
document.
I take your assurance. Then let me therefore explain to my colleague, Mr. Gambert, that what I understand the letter to be saying myself is that we have provided information from our records based on returns submitted by the Kenya Revenue Authority. Is not saying that what we are giving you is the document that was sent. They are saying we have a storage system and we have gathered from that storage system this information which we are sharing with you. I think that is clear, Madam President.
Thank you. I would now like to turn to the other subject matter, which has already been briefly discussed when Judge Fremer posed questions to Mr. Attorney General. But I would first like ask to prosecution whether there are particular materials for which you consider that compulsory measures should have been or should be pursued by the Kenyan government in order to obtain the relevant records.
Well, the obvious example is the bank statements. We managed to come to a partial agreement with the government of Kenya that we should receive bank statements of accounts in Mr. Kenyatta's own name for a period of 3 months. But of course, we had originally asked for those statements for a longer period, and we have explained that the reason why is so that we could make comparisons between the period of time during the PEV and similar months in other years. And the court has approved that request and the 3-year period for which we have asked for bank statements. We have not received 3 years' worth of bank statements. Indeed, we have received no further bank statements following the decision of the Chamber confirming the validity of our request, which was issued on the 29th of July. So that's now over 2 months ago. Yes, certainly, we would submit that if those records could not be obtained by consent, then they should have been obtained compulsorily. The Kenyan government has, I am quite confident, powers to obtain bank records from financial institutions relating to people who are the suspects in criminal investigations. That must be the case domestically, and therefore it must apply to this case as well. There are I dare say, other examples. But of course, we are, if I can put it this way, somewhat stuck in the thickets of the argument between ourselves and the Kenyan government about matters like practicality of consulting the land registry or the company's registry. If your honours are persuaded by what the Kenyan government says as to the absolute impracticality of framing the request made by way of cooperation in a way which will yield useful information, then your honours will come to the conclusion that compulsion would be of no use, because one cannot compel the impossible. If on the other hand, your honours came to the conclusion that in fact there are alternative methods, let me stress, not unlawful methods or extrajudicial methods. I'm not talking about a Watergate break-in here. I'm talking about consulting government lists of telephone numbers. I'm talking about consulting registers of public office holders' interests, the sort of alternative approaches which have been widely canvassed both by the bench and by the prosecution. If your honours were to come to the conclusion that the Kenyan government has shown no desire and cannot explain its lack of desire to explore those alternatives, then compulsion would be appropriate.
Mr. Attorney General, has the Kenyan government taken any steps to compel the production of relevant records?
You know, where it has been possible within the law to carry out an independent interrogation of the requested subject, we have done so. And nothing better explains this than the letter from the governor of the central bank, which is contained in the filing we made on the 29th of August. It is very, very clear that the governor of the central bank has certain powers which the Minister of Lands doesn't have, which the Communication Authority doesn't have, and the governor has been able to use those powers, and he gave us information. So it is not true to say that in all situations where we received a request that we were unable to progress without consent. No, where we were able to do so, like with the governor of the central bank, we did so. Where we were unable to do so, like with the Commissioner of Lands, we were not able to do so, and we requested further information.
So, Mr. Attorney General, you are saying that in this case, the Kenyan government, so far as the bank records are concerned, has taken steps to compel the production of records, or not? Because my understanding from your submission is that the provision of bank records is basically on the basis of consent.
Yes.
So the Kenyan government hasn't taken any steps to compel the production of bank records. Am I right?
There has been no need to. The records relating to Mr. Kenyatta's bank accounts are available. They are before the court. There has been no need to take any other step in respect of that. In fact, the prosecution, Madam President, is not making such a case. The prosecution is making an entirely different one that we would have wanted for a longer period. They are not saying we have not received.
Yes, Mr. Attorney General, the prosecution wanted bank records for a certain period, which by this chamber's decision have been justified.
Then we negotiated with them for a period that we agreed on, and we provided that. You told us, go and negotiate in good faith to agree on a time frame that is reasonable. We did exactly that. And they got that material for that period. If they are reopening the request and saying, now give us for 3 years, that would be a different matter.
Well, I think prosecution has been quite clear for its request for the bank records for 3 years, which this chamber already adjudicated that it's a proper request.
Well, I share that view, Madam President. We asked for 3 years. At the Chamber's behest, we entered into negotiations. It was quite clear that the 3 months which were provided were not satisfactory to us, but that we would take them as being better than nothing, and that we would bring our disagreement about the other 33 months' worth to the Chamber. We did that. We argued it out. The Chamber issued a decision on the 29th of July, and the decision was in our favour, namely, that the full 3 years should be provided. In the 2 and nearly a half months since that time, those records have not been provided.
Mr. Attorney General, do you have any further comments on this?
The position remains as I have explained it.
Now I would like to turn defense. On this specific point of consent. As we noted in our decision of, I think it's 29th July this year, the provision of consent is of course a very helpful means of expediting execution of certain of the requests, although it may not be an adequate alternative in all circumstances. And moreover, the Chamber stresses at this point that the accused is not under any obligation to provide such consent. However, we understand that certain consents have already been voluntarily provided in this case. And therefore, I have a couple of questions for our better understanding. First, is it correct that the defense was only approached to provide information or consent in relation to the request for vehicle records, bank records, and telephone records?
Madam President, first of all, on bank records, vehicle records, telephone records, those were matters with which we gave our consent, and in terms of relevance to this case, that was what I deemed to be relevant. If you would like me to go further into the issue of us giving consent and the way the court has dealt with our voluntary disclosure, I would like to, because that has been a very sore point for the defence throughout this case. And I'm quite prepared to elaborate further on that, but I'm not sure it would be welcomed by the court at this status conference.
Well, to the extent possible to the defense, I'd like to have some information about the consent given by the accused. For example, if the consent, where the consent were provided, they were unqualified consent authorizing the provision of all relevant records, or it's under certain limited conditions. If you don't want to answer, that's fine. But if you can answer, please answer.
I'm quite happy to answer, because we have engaged in a regime of voluntary consent that started right at the confirmation of charges hearing and continued with that approach to this case. And we also entered into the regime of finding evidence that went to the truth of the case by going through a process of voluntary disclosure with the prosecution. It came to the stage of the case where the prosecutor admitted she had no evidence. And we came to that famous hearing where the prosecutor admitted his highly speculative lines of inquiry and about his case. In relation to that, we expected these charges to be dismissed. They weren't.
Mr. Kay, sorry to interrupt, but can you answer more directly to my question?
Yes, I gave unqualified consent to 3 months of bank records for the months of December, January and February that were relevant to the case brought against us, that was relevant to the evidence that was relied upon, and not some other case. We disclosed that. They provided absolutely no support for the prosecution case, and I told the court that. But the court...
Mr. Kay, how about vehicle records and telephone records?
Absolutely.
Is the same?
Yes. Our telephone records was a telephone number that the prosecution already had. That evidence, as this court has been reminded in filing after filing by us, was provided to the prosecution by the authorities in Kenya who run the mobile telephone networks, and they provided them with the evidence. As to providing any other telephone numbers, I haven't. I took the view that the approach to our cooperation in this case had been less than satisfactory. Less credit was given to us for what we had done and what we had tried to achieve than we deserved. And so as a result of that, having looked at the relevant evidence as we knew this case to be, I decided no more evidence would be voluntarily disclosed by me. And that was a matter that I made as a decision because I felt the court was moving in the direction of a defendant having to prove his innocence. And that was certainly something raised this morning. And I know you have countered that by saying, of course, a defendant doesn't have to. But that seemed to be the way that we were turning. And our view was that whatever evidence we produced, further inquiries were suddenly being requested. We need to make comparisons. I have never heard
Mr.
such
Kay,
spurious...
please confine your submission to my very specific question. How about vehicle records? Have you also give some consent?
Yes, we
to disclose vehicle records?
Yes, we've disclosed the vehicle records. And then the request became vehicles used by Mr. Kenyatta. But how on earth are we going to...
Thank you very much, Mr. Kay.
...document every vehicle he had a lift in? And that's what that request amounts
Mr. Kay, is it possible for you, just for the completeness, to file copies of each of the consents?
I think you may have had those, but you've certainly had those in filings because you were appraised of various matters. I think they have already been disclosed.
Chamber hopes, if possible, you can have filing from the defense. That would help us.
Yes, you've already
for
had
the completeness of the record.
Yeah, you've already had those letters, but we will certainly go back to that and provide you with the information.
Thank you very much.
In fact, there was a spreadsheet which the court was given, which had vehicle numbers, yes. So all this has been given.
Judge Henderson has some additional questions.
Okay, actually, Mr. Kay, it's actually not directed to you, so thank you very much. But no, the accused does not have to prove his case, so you can rest assured. It's actually to Honorable Attorney General. I'd like to ask you a few questions, please. The Attorney General. Yes. The Office of the Prosecutor complains that the government of Kenya has not cooperated. That's the nub of this, what we're hearing. And they have asked the chamber to make a finding that that is in fact so, and to refer the matter to the ASP. Quite a serious allegation. And I agree with you that it is not for the OTP to make the finding. It is ready for you to persuade the bench individually, collectively, by majority, that this is in fact the case. This is an unusual case in the sense that the subject of the complaint is actually a person who holds high constitutional authority. And the complaint perhaps is against the backdrop of against this backdrop. And certainly I have noted the constitutional provisions, in particular Article 131D and 132. 131D, which is under the rubric President and Deputy President, and which has its side note, authority of the President. It provides that the President is the chairperson of the Security Council. So that's against that backdrop. Article 132, subarticle 5, which has as its side note functions of the President. It provides that the President shall ensure that the international obligations of the Republic are fulfilled through the relevant actions of the relevant cabinet secretaries. So putting that on one side, you have a situation where and it's quite an unusual case. The person who forms the subject of the request to the state, the request from the state party, the request to the government of Kenya, is himself perhaps in a constitutional position. Is that a fair reading of the constitutional provisions?
First, thank you. Thank you, Judge. I am happy to know that you agree with me that it is not the individual opinion of any lawyer before this court, no matter how learned, that will determine whether there has been cooperation or not. That will be a judicial determination by the court itself. I thank you for that. Secondly, and I'm coming to your question very shortly, I think I need to remind the chamber with respect that the cooperation of the Kenya government with the ICC predates the election of Uhuru Kenyatta. Because sometimes that is forgotten.
No, Mr. Attorney, I have a keen eye on the clock, so I know that, and we are mindful of your submissions, which we have heard in length on a previous occasion, and I recollect them quite clearly. Yes. So that I understand that. So perhaps if you could...
Yes, so then let me come to the second point. So that an argument that says the Kenya government is not working with the ICC because Mr. Kenyatta is in the office of head of state is fallacious. It is totally fallacious and baseless, because I personally was in contact with the prosecutor, with the registry, long before we held the election that brought the current administration to office. So let me leave that behind and come to the next point. There is an argument that there is a constitutional responsibility for the president to facilitate the enforcement of law. Generally, constitutional law...
Well, we're dealing specifically with the compliance with international obligations, of which this is the complaint. And what I would like to come specifically to is it something that perhaps is there on the face of it any conflict of interest?
No, there isn't, Judge, there isn't. All I have said before, and I think it bears repeating, that the International Crimes Act of Kenya is the law that domesticates the ICC statute. The president and every other person in Kenya who looks to understand what our treaty obligation is looks to the International Crimes Act. That act identifies 3 focal points for cooperation with the court. The Minister for Foreign Affairs, the Minister for Internal Security, and the Attorney General. If, therefore, there is any failure, any misreading of the law, any administrative or any administration failure in cooperating with the court, then you must ask the foreign minister, you must ask the interior minister, you must ask the attorney general. That's one argument. The second argument, which is more fundamental, and you have alluded to it, Judge, is this. This is an unusual case. Uhuru Kenyatta was charged before this court as a suspect before he took over the management of the Republic of Kenya. After he took over the management of the Republic, by dint of the same constitution, the president could not place himself in any circumstances where he would be deemed to have in any way impeded the impartial processing of this case.
All right. I don't want to cherry pick any of the specific requests, but what has come up from time to time this morning is the telephone records. So perhaps that might be a good one. So I'm not cherry picking, but that's one I will perhaps use. Now, the court has not had the benefit of seeing the correspondence dated the 1st of September, as it came in, I think, after the last filing. But from what I understand, it contains material in which the Telecommunications Authority indicates that they cannot act unless they are provoked by some court order. Is that correct?
Mm-hmm. Correct.
Now, the learned presiding, my sister, had indicated that she had asked a very specific question about formal steps being taken. Now, my recollection in an earlier hearing was that essentially your complaint was that the prosecution could not just simply come to you and say, give me the keys for the barn and give me what you have, that they needed to come with a court order. And once you had, and that was unacceptable, but once it had basically the stamp of the court, then you could be moved on that basis to make such a request. Is that a fair recollection?
That is not actually accurate. And let me use the example of the other Kenya case, if I may, because it will explain this point very clearly. In the second Kenya case, we came to the trial chamber. The trial chamber said there are witnesses who have refused to testify. Go and arrest them and bring them to the ICC. And I said to that chamber, I have no authority to do that. We cannot do that because we must do everything in accordance with Kenyan law as well. However, when the chamber finally said that these witnesses are compellable, I said to the chamber, the other parties are appealing, that is their right to do so. Give me the names and give me the summons. The prosecutor will tell you, I am the one who provoked the request to the prosecutor. I said, give me the summons. I will ask the police to serve all the 8 people you say. They will make an election. Those who want to come will come. Then we will have no problem. You will have no problem, I'll have no problem. Those who refuse, we will now go into a legal process. That's exactly what has happened. So let's come back to telephones.
Yes, and when you are answering, because I don't want to take up too much time.
Okay.
But
I'll be very brief on telephones.
Yes, but what is, has been some anxiety here.
Because they have already...
Just a moment, Attorney, is that here it is, you have the telecoms authority, here it is that it is a person that the prosecutor says is not somebody who you would have any difficulty in acquiring telephone numbers. Here it is where you have the telecommunication authority.
I must respectfully disagree.
Yes.
Because the letter from the communication authority says, and we have made this point before several times, before 2009...
I interrupt, my learned friend. I've got a copy of the letter here. The bench hasn't. It's crazy that you're relying upon my summary. Let me pass the letter up.
Yes, Mr.
Judge, the letter from the communication authority makes it very clear that there was no regime for the capture of information regarding subscribers during the period in question. Even if I had by some way or other an order that told me, go to Airtel and Safaricom and get this record, they themselves have already, we have filed their letter saying we did not have compulsory data capture prior to 2009. So it's not about a court order. It is not about cooperation. It is not about disclosure. It is about evidence that is either available or not available. Let me give you another example. The prosecution has said, give us security intelligence reports. We have come back on 2 occasions and said, these are the reports and this is what they say. There is no court order that can compel the intelligence service to issue a different report. So that is the end of that matter as far as I can see. The Cabinet Secretary for Lands has said, give me these particulars and I'll conduct a search yesterday. Without these particulars, I can, even if there was a court order, what would the court order say? Conduct a search.
Have you attempted to get a court order with respect to the telecommunications post the 1st of September?
I beg your pardon?
Post the 1st of September, based on the letter. The letter says, I haven't seen the letter yet, but essentially the letter, it says that there's, okay, paragraph 2 says there's no regime for capturing the information. Paragraph 1 requests an order. So the question is, have you taken any steps, first of all, to inquire subsequent to receipt of this letter? It's a direct question.
I think I need, yes. I need to, I think, refer you, Judge, to the 2 letters from the service providers, because I think that they...
We have those letters. Those letters indicated that
they are responding to me.
Okay, those from the court's recollection, those 2 letters indicated that they would require certain, the term of art, I think, is the MSISDN or the mobile numbers. Is this correct?
Yes.
Right.
And that is why this is a circuitous, this is, we keep going round and round and round, because I am told, can you get a court order to compel? And I'm saying, even if hypothetically that were possible, what would the court be invited to compel Safaricom to do? Because Safaricom's answer would still be the same. Give me the mobile number you have in question, then I will search it.
So what you're saying
And
is
the prosecutor says, I don't have the mobile number and have never had it. So,
it's that. Thank you, Mr. Tilley.
Thank you. Before giving the floor to Judge Fremer, Mr. Kay, about this consent, actually, I confirmed that we have already certain materials which you disclosed, but we don't have your consent letters given to the authorities themselves. Is it possible for you to provide us with those letters of consent?
I'll make steps to trace the chain of documents.
Thank you very much.
Yes.
Judge Fremer.
Thank you for the floor. I have just a last question for Mr. Gumpert. Mr. Gumpert, at the beginning of this status conference, you called the situation before us, from your point of view, as a deadlock. So now, after status conference, I would like to know whether you retain your position or you see any way out.
No, it's still the prosecution's position that throughout the 2 hours of this status conference, there has been no indication from the representative of the government of Kenya that they intend to adopt any of the measures which the prosecution has urged upon them, and which in some cases the Chamber has suggested they should adopt, to overcome what they say is the impossibility of providing any more material. And as long as that remains the case, then we are, I would respectfully submit, deadlocked. May I make one, I hope, helpful remark? Your Honours have seen one of Mr. Kay's consent letters. It is confidential Annex C to his filing 945. I can't speak to the others, but I was flipping through my papers and that occurred to me, and I thought that I could usefully say that in a non-partisan way.
Thank you.
may I have half a
It was just my concern. Maybe you should,
Yes, thank you.
in terms of fairness,
Thank you,
to get
Judge.
a chance to react.
I would like to respond to that by saying that it is totally untrue to suggest that we are deadlocked because the government of the Republic of Kenya is failing to do something. We have come here today offering many alternatives, including requesting, like we have done before, for the prosecution to give us actionable information, material that can help us to access. It is not true to suggest that these registries are inoperative, that they are non-functional. They are functioning registries. They require information. Please give us that information. We will supply whatever you need within 72 hours.
Thank you very much. And that brings us to the end of the matters to be addressed today. We have noted the submissions made and will take them into consideration in our decision making. We thank very much the parties and participants and the Mr. Attorney General in particular for their contributions.
Make a very short request, Madam President, very short, in half a minute.
Yes.
At tomorrow's status conference, the representatives of the Kenya government have not been permitted entry. In our very humble view, we are amicus in the case. We may be denied a right to speak or to make submissions, but I would very much request, Madam President, that we be permitted to be present.
Thank you, Mr. Attorney General, for the submission, but we have already made a decision. We have already made a decision, and that today's status conference, only parties and legal representatives be invited. No amicus.
I think Your Honour may have misspoken. Tomorrow's status conference.
Oh, yes, tomorrow's status conference.
Thank you.
Yes, that's the end of this status conference today. And I would also thank, before I forget, the court officers, interpreters, court reporters, and all other courtroom staff for their assistance today. The status conference is now closed, and the bench will rise.
All rise. We will